Man, oh man, this is some case. We have to, it's got so much to it. We got to bring in another one here. We got to bring in another great guest to be able to help us break this down. I may have three by the time it's all said and done because this is just an amazing case. Gilbert Parris, former prosecutor in Kings County. He does federal and state defense work in the great state of Brooklyn, New York. How you doing, Gilbert?
I'm doing great, Bob. Thanks you so much.
Yeah, great to have you on. Listen, let me just start with you. First of all, I got to compliment your outfit. It's got the checkers, you got the vest on. It's almost like we called one another.
I know, I think flattery's the greatest form of invitation. I saw you there. I had to take a quick change.
We got to take a picture after this. So, Gilbert, let me get to this. I mean, when you have, just based on your experience, I've just never seen it happen. I've seen 404 information come out with other act evidence or bad act, as they call it, evidence. But I've never seen all of the people that were actually victims testifying in court where a defendant had to defend himself literally against each of those things. Different than Cosby, where there was one victim and the other witnesses were brought in as 404 witnesses. What are your thoughts about that?
Right. I mean, I think it's interesting. This is one of those cases where prosecutors, judges want to consider if there's a pattern, as you know, what we call the Molyneux exception, where all of these elements committed against different people. And if different people have the same accounts, none of them know each other, none of them have collaborated, they have no reason to group together in order to try to be overzealous. A lot of times people feel that the jury should be entitled to hear that. And I think that the burden is incredible to get over, to be able to establish why do all of these different people have such a similar story.
Yeah, and Professor, you had mentioned off camera, and I think this is an important point, like we're asking why would this be done, because it does come with significant appellate risks. And to your point, Gilbert, there's the law of 404, but there's also cases that interpret that law. And you had made a comment to me that it may have been a tactical decision by the prosecution that they were willing to risk the appellate issues because individually the cases were weak, but to get combined, to Gilbert's point, they become a mighty mountain to overcome.
Absolutely. So you could think about tactical issues on both sides. So for the prosecution, if you're able to get all this evidence in together, it makes a weaker case much, much stronger because it tends to show that this person has some type of common scheme of operation. On the other side, if you're the defense and you feel that you have a somewhat weak case, since this does have a likelihood of presenting possibly an appellate issue, let it in and then work your magic on appeal, knowing that your case at trial is kind of weak. Okay,
and I just want our folks out there to know that I don't want to say, Professor, it was just myself and Gilbert that had the pattern. You have the pattern too, but you
Absolutely.
Don't have just as a sidebar. Okay, all kidding aside, Jane Doe number 4. This is an individual who was allegedly 17 years old at the time of the incident in 2003. On count 7 in the first trial, forcible rape, the jury was deadlocked, as well as rape of an unconscious person. She claims, I came forward late because I had had sex with him before, and on the second occasion I woke up in this drunken fog, and he was having non-consensual sex with another person there, and I wouldn't be believed. A very common, story that's out there that we hear over and over again in the legal world. Let's listen to a little bit of her direct examination from the first trial. Okay, so that was Jane Doe 4, alleging at 17 years old that she was sexually abused. I wish that they had a camera another camera in here, so when we're thrown to these clips, you could hear our off-camera. You call it off the record instead of on the record. Professor, you were saying you were interested in the manner of cross-examination here in terms of all the things she did voluntarily. Expand on that for me.
So it's very interesting that, gets this in the mind of the jury. If you saw the defense attorney went through, and he did a quite effective cross. Didn't badger the witness, but went through all the things that she did voluntarily. She came to the party voluntarily. She drank voluntarily. Did all these things voluntarily, and then asked her, so Mr. Winslow did not put anything into your body, no one did anything on you. And that, coupled with the fact that she has already testified that she had a prior encounter or relationship that was voluntary with the defendant. Now, we could go on and on about our society and what that says about us when someone is a victim of a sex crime, having had a prior relationship with that person. unfortunately, it's a higher mountain to climb.
Yeah, and Gilbert, I want to talk about that because we were talking about the societal differences and how these cases are handled. I can tell you from when I was a baby prosecutor to now, there's a completely different mindset with regard to, oh, she was under the, back in the day, it would have been she was under the influence or whatever. It never would have saw the light of day. But today's a different story. But there's also a downside to that. I'd like you both to comment briefly on that.
Absolutely. I mean, I was saying that among my own relatives, even my son, some of his friends, when I talk to certain men, one of the things that I caution them about when they're involved in certain consensual sex acts, or if it's going to be a girlfriend, to make sure that they're conducting themselves in a manner that they cannot be set up for the possible charge of a false rape. Now, we had discussed this earlier for a little while, the pendulum sometimes swings too far to the right or too far to the left, and we don't quite hit the middle. And I think that the goal, and in every trial, of course, the goal is supposed to be to hit that middle. So some of these things, in terms of focusing on all of the things that were voluntary that evening, the jury wants to be able to consider whether or not sex at the time was in line with everything that was voluntary beforehand. However, it doesn't mean just because there were certain voluntary acts, having a drink, dressing a certain way used to be one of the things that people take into account, even being very familiar with each other. And unfortunately, as you and I know, there are too many attackers, I don't know the exact percentage, but far too many attackers that know their victims and actually utilize that to be able to try to intimidate them from reporting or eventually going to trial. However, I think in this individual case, the jury needs to be able to consider all of the things that happened on that evening.
It's interesting, ladies and gentlemen, how society changes and the prosecution and defense mindset and juror mindset changes. These are excellent points. Of course, any kind of sexual assault should be aggressively prosecuted, but there are, unfortunately, some instances in which false allegations are made as well, and we want to make sure we ensure due process. You can only get this kind of commentary here on the Law and Crime Network. Of course, gavel-to-gavel coverage. We're going to take a break. We'll be right back.